I'm Assistant Professor Dr. حيدر المحسن الجبوري, and from the University of Babylon College of Law. The title of the lecture for this today is talking about the conception of international law. And this is material is studying for the class stage of the College of Law. In this lecture, we're talking about the different legal aspects of international law as a branch of public law. We have in this lecture the conception, the definition, the nature, the legal nature of the conception of international law and the sources of international law. And the subject, finally, we have the subject of this kind of law. In the beginning, as you can see here, the conception of international law is a debate subject between jurists of law, especially international law. So we have many definitions, we have many conceptions about the international law, but we have one here, and this is the fundamental conception of international law, and the majority of jurists as agree with this conception. The international law is a body of rules they are governing the relation between sovereign state and between state and international organizations. Of course, the international law is dealing with the international legal persons, especially the state. And in the past, the international law is dealing fundamentally, exclusively, just with the states. But after that, after the evolution, this kind of law, they enter the international organization, especially after the decisions by the International Court of Justice in 1989. That case named the case of the compensations, injuries of the employments of the United Nations organizations. So the international law is dealing with the states and international organizations. So the answer will be here. What are the nature of the relations that governed by the international law? The relations is maybe cultural, social, political, and economical relations between the state and international organization. All the kinds of field of the international law. The beginning of the term international law, when it's appeared, when was appeared? The term international law was appeared for the first time in 1780 by Jeremy Bentham, the philosopher English, the jurist, English jurist. In his writings, Introduction to the Principles, Morals and Legislation, since about in 1940 in the English language, it's replaced with the other terms. In the past, the many terms using to consideration of the international law, such as the law of nations, the law of the population, as using in the Roman writings. But now the modern jurisprudence using the modern terms that name international organization, international law. The international law are using between the jurists. We have two conceptions, fundamental conception of international law: the tradition and the modern. The tradition is exclusively dealing with the states, as we remember in the past time. So the traditional conceptions of international law as the law of nations, exclusively the province of nation states. Oppenheim was even more explicit when he wrote, "State slowly and exclusively are the subject of international law." Meaning, I'm speaking about the early years of the evolution of international law. So Oppenheim and the other jurists talking about the exclusively, the state is the only state of subject of the international law. Before that, we know the second subject, legal subject, the international organization. So the tradition view is talking about that the law is the body of rules which are dealing with the states only. But after that, and in the next time, there is evolution appear to the conception of international law. Is that talking about the modern, meaning the modern of conception of international law. So, as we see here, although international law may have developed as a system of rules governing the relation between sovereign states, it has developed beyond the states and international organizations. This is the modern conceptions, including all the non-state entities. Such as the pressure groups, the individuals, the corporations, the multinational companies. So when we're talking about this modern concept, we're talking about another subject, another international legal persons besides the states and international organization. And therefore, as we can see here, the international law, according to the modern concept, is the body of rules of conduct enforceable by external sanction, which confer right and possibility. In that sense, international law, simply, broadly, may be the following: the law of the international community. Another point of our literature is talking about the sources of international law. Sources of international law is the most important topic that we're talking about. But this topic, the source of international law, is not clear. So we try to clear to you and to especially talking about the Article 38 of the Statute of International Court of Justice. There is no provision, there is no express, there is no provision clear talking about the source of international law. So many jurists sign to the Article 38 of the situation of the International Court of Justice. When we court, the International Court of Justice has to apply while deciding on the dispute submitted to it. So the sources, according to Article 88 of the Statute of the International Court of Justice, will be number one, the first sources are international conventions. Bilateral and multilateral international treaty. This is the most important thing. The second is international custom, as we said in the next time, is a behavior by majority of the states in the international society. The general principles of law, and this is a well-known sources, as we know. The decisions of international courts, all the international courts, the International Criminal Court and the International Court of Justice, and even the national courts, the local courts, all decisions issues from the local courts may be a source of international, and the teachings of the most highly qualified officers of the various nations. And finally, justice and equitable principles. The question is, now we have the details, these sources and legal sources of international law. We begin with the first sources. International law treaties are known by a variety of different names, ranging from convention. It doesn't matter when you named the international treaty with another terms. Maybe named a charter, a general acts, a pact, a convention, international. It doesn't matter, because the law of treaties says that no value legal between these names. You can using one of these names to represent the international treaty. So all these terms refer to similar transaction, the creation of writing agreements whereby the states participating band themselves legally to act in particular way to set up particular relations between themselves. So, but we have needing to remain definition is that international treaty is a writing agreement for a mutual understanding between two or more than two states of international law as well, expressing their rights and obligations. From this, we can analyze these conceptions and we can find many categories of this simple definitions. Number one, the international treaty will be a writing agreement. That means the oral agreement or unwriting agreements. You cannot take about the international conventions or a treaty because this agreement must be a written, and for a mutual understanding between two or more than two states. As we say, not only the state or international organization may be a subject of international, but the subjects including the individual corporations, multinational companies, and non-state entities. So this is the meaning of international treaty, and of course there is a kind of international treaties. The second is international custom. This is the second cause of international law listed in the Statute of International Court of Justice and as a basis of general practice accepted as a law. And this is may be defined as understood to mean certain rules which have come into existence by the conduct of the state in their relations. And absolutely the most important things is that the differences between the international customs and international treaties. International treaty requires expression of consent, and this is not exist in the international custom. International custom as evidence of a general practice accepted as law, and this is the most important sources of international law, and can we define this source as understood to mean certain rules which have come into existence by the conduct of states in their relations, and meaning the behavior, that repeated behavior more and more, and to any kind or nature of behavior in the international relations between states or between international organizations can be considered as international custom. But there is another thing, is important point of this subject is that the differences between the international treaty and the international custom. The international treaty have a short time, and the international custom needing to the long time to be suitable, to be firmed, and in the same time there is a differences between the international and the international custom and international treaty by declare. The international custom is inviolable, not declare. It's not declared, but the international treaty, because it's recorded, because it's writing and have existed in the materials, it's clear and recorded. So you can easily belong to the provisions of the international treaty and you see it, but the international custom is not, because it is invis, not clear, not writing, not recorded. So there is differences. Another difference, another categories between both of them is that the treaty required an expression of consent, but the international custom required a taste consent of the states, because it is have a long time and in the same times it is not clear. On the other hand, the international custom, as we remember, which have been observed by states for a long time. The third sources of international is general principles of law, and this is a general norms in the form of general rules which are accepted and recognized by the majority of the states. We have examples of the general principles of law. Number one, the equality of sovereign state, and the principles of respect to the sovereignty of all states, principles of non-intervention in the internal affairs of the states, and this is famous principles, and it is well known in the international relations. Every state maybe don't intervene in the international affairs or internal affairs of the states, of any states, the other states. The principle of non-use of force, and this is the principle, it's famous, and we can see it, we can find these principles in the Charter, exactly the Article 2 of the Charter of the United Nations Organization. That remember many principles of the Charter, and he may be a God when you states working in the international relations. Every state maybe don't using the force and or the three things we use of force in the international relations. The principles of non-aggression in international relations, the respect to the principle of self-determination, to respect the human rights, the respect the pacta servanta, and the other. There is examples about the general principles of law, and as we say, it's the most important sources of international law. We don't think now about the branches of international law. There is many branches of international law because the international law is a evolution branch of law, and day after day they developed and appear a new branch of international law, such as we see here, the international law of the sea. This is dealing with the permissible maritime activities, navigation of rights, the rights of the coast of the states, and all the maritime rights of all the states, mineral rights, jurisdiction over coastal water, and the other fields. The second branch is talking about the international environmental law, and this is the most important branch of international law. It's talking about the management and transactions of the pollution, the problem of pollution as a global problem in all the world. And as we know, that the pollution is a global problem, and one of the most challenges of the international society and all the governments, international conferences, especially that adopted by the United Nations organizations, talking about this subject, the pollutions and all the damage that happened by the pollutions. And now speaking, all the jurists, all the writers, the experts in the United Nations organization talking about the law of the renewable energy, international renewable energy. And step by step, now especially the evolution states transfer from using the oil and gas as energy to the new or the clean energy in all the fields. So this is the most important branch of international law, and as we say, they're dealing with the problem of pollution. Finally, thank you for all, and good luck for all. Thank you very much.